Good morning. Welcome to the first session of your training on basic digital forensic analysis and investigation. This session has two parts. In the first part, you will learn about Republic Act number 10175 or the Cybercrime Prevention Act of 2012. On the other hand, the second part covers the cybercrime warrants as provided under the cybercrime law and the rule on cybercrime warrants promulgated by the Supreme Court. So, in the presentation is our outline of discussion. We would discuss about the history of cybercrime laws in the Philippines and then go to the salient features of RA 10175, and then we would mention what are the enforcement agencies under the Philippine cybercrime law. Okay, as we know, any discussion of cybercrime in the Philippines has reference to the I Love You virus, which placed the Philippines on the global cyber map. So what is this I Love You virus? The I Love You virus is a strand of virus created in 2000. It created an estimated $15 billion in damages. However, the creator of this I Love You virus, which is a Filipino, was released after being caught because there exists no law against malware at that time in the Philippines. It pushed the Congress to pass the first domestic legislation that touched on cybercrime, and that is Republic Act number 8792 or the E-Commerce Act of 2000. Said law punishes the crime of hacking or cracking, which is basically similar to the CIA offenses under the current cybercrime law. So later we would discuss the CIA offenses, which is one of the type of cybercrime offenses as provided in the cybercrime law. Not long after, the Supreme Court promulgated the rules on electronic evidence in order to complement the E-Commerce Act and to assist the courts in applying the same. In 2014, the Congress legislated the first comprehensive law on cybercrime, and that is the law which we would be discussing right now, which is RA 10175, which is basically patterned after the Budapest Convention, the first international treaty on cybercrime, and in which the Philippines is a signatory. Then, the birth of the rule on cybercrime warrants, which fills in the gaps between RA 10175 and the rules of court. This will be further discussed in the latter part of the presentation. But briefly, this rule on cybercrime warrant supplements the existing rules of criminal procedure. It provides the procedure for the application and grant of cyber warrants, the custody of computer data, and also provides for the destruction of computer data. So, what is the policy of the state in promulgating our cybercrime law? So, it is stated under RA 10175 that the policy of the state is to first, protect and safeguard the confidentiality, integrity, and availability of computer data, computer and computer systems, networks and databases, and to adopt mechanisms to effectively prevent and combat cyber offenses by facilitating their detection, investigation, and prosecution at both the domestic and international levels. Why is it necessary to mention that domestic and international levels? This is because the nature of cybercrime itself necessitates international cooperation. Kung mapapansin nyo, most of the in investigating and prosecuting cybercrime cases, hindi lahat ng ebidensya na kailangan mo andito sa Pilipinas. most often than not, the computer data that you need is available or in the hands of a service provider, which is more often than not a foreign entity. That's why there is a need for international cooperation when we are investigating and prosecuting cybercrime cases. So, consistent to the said state policy, RA 10175 has three salient features. First is the substantive provisions, which provides for the criminalization of certain acts that will constitute as cybercrime. Second would be the procedural provisions of the cybercrime law, which provide law enforcement authorities with technical tools that would aid them in conducting cybercrime and cyber-related investigations. So these procedural tools are the cybercrime warrants. So ito yung mga gagamitin natin in order for us to get the computer data or the evidence that we need to further a cybercrime case or to further an investigation of a suspected cybercrime incident. So the third part of the cybercrime law would be the provisions on international cooperation, which provide for mechanisms that will foster and enhance collaboration with foreign counterparts, taking into consideration the transborder nature of cybercrime and cyber-related offenses. Now let's go to the main meat of our discussion, the substantive provisions of RA 10175 or the cybercrime law. This training is on basic digital forensic analysis and investigation. So why is it relevant to know and be familiar about the punishable acts under the cybercrime law? The importance of getting familiar about the cybercrime law stems from the very nature and definition of digital forensics itself, which is the application of forensic science to electronic evidence in a legal matter. So in order for you to conduct sound digital forensic analysis and investigation, you must know what is the crime you are investigating, what was the crime that was probably perpetrated by the cyber criminal, what are its elements, and what are the necessary evidence needed to prove said elements. So once familiar with the elements of the crime that you are investigating, you know what digital evidence to look for when you are doing your digital forensic analysis, and you will know whether the electronic and digital evidence that you stumbled upon during the course of your analysis are relevant to the case or not. So under the substantive provisions of the RA 10175, the cybercrime offenses are divided into three types. The first type would be, as provided in the presentation, are the offenses against the confidentiality, integrity, and availability of computer data and systems. The second type would be the computer-related offenses, and the third type would be the content-related offenses. Under the cybercrime law also, as provided under Section 6, there is also a provision, although not which covers all traditional crimes, those crimes provided under the revised penal code and special penal laws, where their commission was by, through, or with the use of information and communications technology, and where the cybercrime law provided that if these traditional crimes are committed with the use of ICT, the penalty would be 1 degree higher than that provided in the RPC and the special penal laws. So technically, this is not these are not cybercrime offenses, but it just provides for the use of information and communications technology as a qualifying circumstance that would raise the penalty. Okay, let's now go to the first type of cybercrime, which is the offenses against the confidentiality, integrity, and availability of computer data and systems. So these offenses under this first type, the CIA offenses, it is about, these offenses are violation of the security of computer data and the computer systems. CIA, confidentiality, integrity, and availability are the components of security. So what is confidentiality? When we talk about confidentiality, we are talking about the privacy of your computer data. Anong ibig sabihin nito? So if your computer data, yung mga data na nakastore sa iyong computer, when we say computer, it is not just your personal computer, but it also covers your cell phone. Cell phone, these gadgets, we call anything that can store memory, we consider this as computers. So the computer data inside your computers, may it be a PC or a cell phone or any information and communications technology gadget that you have that can store memory, yung computer data na nandun. And if you treat the computer data inside this gadgets as private or confidential, anyone is obliged to respect the confidentiality of the computer data. So that's or the privacy. Hindi nila basta-basta pwedeng buksan or basahin, or hindi nila basta-basta pwedeng i-access yung inyong computer data, because the privacy or the confidentiality of that computer data is protected under by law. Next is integrity. When we say integrity, we are talking about the trustworthiness and accuracy of the computer data stored therein in your integrity, the trustworthiness and accuracy of your computer data or the computer data stored in your computer systems. So anong ibig sabihin nito? Ibig sabihin, kung ano yung computer data na nilagay mo, kung ano yung in-input mo doon, you must be assured na walang ibang gagalaw doon, and that kung babalikan mo, it is accurate. So it makes the cybercrime law makes it punishable for anyone to alter or modify this computer data or the computer data stored in your computer systems. Next would be availability. When we talk about availability, we talk about the accessibility of your computer data and the computer data stored in your computer system, as well as the the ordinary function of your computer system. So hindi pwede na pag may ni-store ka doon sa iyong computer or yung computer data mo is yung ibang tao, i-delete na lang nila bigla ang iyong computer data, or they would make a modification in such a way that modification would alter or suppress or affect the accessibility of your computer data. Okay, so what are the offenses against, or what are the CIA offenses? There are 6 CIA offenses enumerated under RA 10175. This is under Section 4 of the law. These are illegal access, illegal interception, data interference, system interference, misuse of devices, and cyber squatting. Let's now go first to the discussion on illegal access. So what is illegal access? Illegal access is committed when the offender enters into the whole or any part of a computer system, and such access or entry is without right or not authorized. So the common example na madali nating intindihin would be unauthorized access to your personal computer, to your Gmail account or your Facebook account. So commonly, ang mga reports na nakukuha ng ACG, the PNP Anti-Cybercrime Group, and the NBI Cybercrime Division would be illegal access pertaining to unauthorized access on social media accounts, like for example, Facebook and Instagram. Yan yung mga currently the bulk of the reports about illegal access. So what are the key points that we should take note when talking about illegal access? First is that the access should be without right. When we talk about without right, it is without or in excess of authority, or without legal justification, or without a court order. So, paano ba to? For example, ngayong ECQ, kung mapapansin nyo, most of the employees are working from home. So, kapag nagka-problema sa kanilang computer, nagugulat sila that their IT personnel can remotely access their computer and fix the computer kahit nasa bahay sila, and their IT personnel is somewhere other than sa bahay nila. So, in this, if the access is authorized, ikaw mismo yung tumawag dun sa IT personnel nyo na ayusin yung iyong computer, there is no violation, or there is no violation called illegal access, because the access of your IT personnel to your computer is with right. However, kahit na pinayagan mo siyang i-access ang iyong computer, but ang access na binigay mo sa kanya is limited only in fixing yung mali sa iyong computer. If nag-exceed siya doon sa authority na binigay mo sa kanya, like for example, in addition to accessing your computer to fix its problems, binuksan niya yung Gmail account mo or binuksan niya yung mga messages mo, your IT personnel is acting in excess of authority. So, basically, he is violating the provision on illegal access under the cybercrime law. Okay, what else? For example, a police officer, nakakuha siya ng cellphone ng isang taong naaresto. Hindi niya to basta-basta pwedeng buksan yung computer ng taong naaresto niya or yung cellphone ng taong naaresto niya without legal justification or without a court order allowing the examination of the computer ng taong nahuli. The police officer may be liable under the provision of illegal access in the cybercrime law. So, in addition to the violation of cybercrime law, the evidence that the police officer would get from that computer cannot also be used as evidence in court. Okay, so that's the first key point that we should remember. The access must be without right, without legal justification, or without a court order. Next, when we say access, what are we talking about? When we say access, it is to instruct, to communicate with, or store data in, or retrieve data from. So, kapag binuksan mo yung kanyang computer, you communicate with that computer, or nag-input ka, nag-modify ka, or when you store data in the computer, when you retrieve or copy data therein, those are, we call this entering and accessing the computer. Okay, when we say computers, when we talk about computer system, we also, ang pagkakaintindi natin yan is hindi lang yung mismong PC, but also any device or group of device interconnected or any other interconnected or related device with data processing capabilities. Okay. Illegal access covers the basic offense of dangerous threats to and attacks against the security of the computer systems and computer data. So, what is the risk when you are a victim of illegal access? Or why should we be wary of illegal access? Because any intrusion caused by illegal access may give access to confidential data, This confidential data may include passwords, information about the targeted system, and secrets to the use of the system without payment, or even encourage hackers to commit more dangerous forms of computer-related offenses like computer-related fraud or forgery, or even computer-related identity theft. So, aside from the access, the unauthorized access, ang isang ikakatakot mo is that access may lead to access also of the computer data na nandun. Baka doon mo ini-store yung mga passwords mo, other personal information. So, most often, illegal access is a preparatory crime. So, you access it not only for the purpose of just accessing the computer, but also to commit other more serious crime like computer-related fraud or forgery, or to get in personal information or identifying information stored in the computer in order to facilitate the commission of computer-related identity theft. Okay, now let's go to the second CIA offenses, which is illegal interception. So what is illegal interception? Illegal interception is in illegal interception, there is a transmission of computer data to or from or within a computer system, including electromagnetic emissions from a computer system carrying such data. Such transmission is not intended for the public, and an offender intercepts such non-public transmission by technical means, and such interception is without right or authority. So, in basic terms, ano ba tong illegal interception? In illegal interception, there is a non-public transmission of content data. There is an ongoing communication from 2 points. Okay, so while there is an ongoing communication, for example, isipin na lang natin, kapag ikaw, a basic example, a basic everyday example, you are communicating in Facebook Messenger. So while there is a communication, there is someone intercepting your communication. For example, ako, may kausap ako, nasa ibang bansa. So habang nagko-communicate kami during through Facebook Messenger, may isang tao na nag-intercept or nakakakita or nagmo-monitor nung aming pinag-uusapan, or nagmo-monitor nung ongoing communication. So the interception, so this dapat yung interception na nangyayari or yung kanyang pagmo-monitor or kanyang pagmo-monitor ng conversation, it must be without right. And the monitoring or the interception uses technical means. When we say technical means, it uses electronic, mechanical, or digital devices or technology in order to facilitate such interception. When we say interception, it is to listen to record, to monitor, or to surveil the ongoing communication. What are you monitoring? What are you intercepting? It should be non-public transmission. Ibig sabihin, these are communication that you intended to be private or non-public. Diba? So, information is intended only for authorized recipients. So, for example, the communication is public. We are doing, for example, TV, a communication using we expect it to be broadcasted on TV. So, this is a public communication. So, kung sakaling may nag-i-intercept or may nagmo-monitor ng communication na nangyayari between me and I know that the communication would be public kasi makikita yung messages ko on TV, someone who monitors this, yung mga nanonood, yung mga nagre-record, or yung mga nakikinig, they are not violating illegal interception because the communication that is happening is not private. It is for the public. Next, so what is the communication? The communication is what we are communicating is computer data. So it could be the content data, tulad nga kapag Facebook, if it's on Facebook Messenger, the messages that I am exchanging with the recipient who is using another computer, these are computer data, content data yung pinag-uusapan namin. Okay, illegal intersection, the provision aims to protect the right of privacy of data communication. And this provision upholds the right to privacy of correspondence. It represents the same violation of the privacy of communications as traditional tapping and recording of oral telephone conversations between persons. So you would see in the slide, in the presentation, we see an illustration of illegal interception. So first, yung unang illustration, we would see what is happening in a regular connection or regular communication. So for example, online shopping through the merchant's website. Kapag ikaw nag-online shop, you input and you pay online also, you input your details, your payment details doon sa website noong merchants. So nilalagay mo doon yung card number mo, yung validity date ng yung credit card and your CVV. So you input these details. So the inputting of your details, yung ginagawa mong pag-input ng communication doon sa website ng iyong merchant, this is considered also as communication. And if someone, makikita nyo doon sa second illustration, if from your browser to the website of your merchant, yung mga ini-input mong data, someone is intercepting, someone is monitoring, surveilling, or recording the details, the computer data that you are inputting, that is called illegal interception. So, ang illegal interception, hindi lang yan yung nag-uusap kayo through FB Messenger or may nagbabasa ng iyong or may nakikinig sa inyong usapan sa FB Messenger. Hindi lang yon. There are any communication, like for example, a communication from your computer to your merchant's website, it's called communication also. Kapag may nanonood or may nagsusurveil, may nag-i-intercept noong mga ini-input mong computer data, it's also called interception. But what if tapos na yung communication? For example, yung may nag-access tapos na kaming mag-usap nung kausap ko sa FB Messenger, but the computer data, the content data, our communication is stored doon sa aming FB Messenger app. What if someone, the perpetrator, after the communication would access our FB Messenger para mabasa, para i-record, or they took a screenshot, or they had a surveillance of the communication that I had? Illegal interception pa ba to? Hindi na. Because when we talk about illegal interception, ang interception, that should be done while the communication is ongoing. If the recording or getting a hold of the communication happened not during but after the communication, ibang cybercrime na yung na-commit doon. It can be illegal access na. Kapag ongoing yung communication and someone intercepts it, we call it illegal interception. But if the communication is not ongoing and someone accessed the communication that we had, or someone got the information that I input, for example, in the website, ibang cybercrime na yon, pwedeng illegal access. Next, let's go to the third type of CIA offenses, which is data interference. So, in data interference, the offender alters, damages, deletes, or causes the deterioration of computer data, electronic document, or electronic data messages, including the introduction of or transmission of viruses. And such act of altering, damaging, deleting or causing the deterioration of the computer data or the electronic document was done without right or authority, and the alteration, damage, deletion, or deterioration is intentional or reckless. So, when we say deletion, anong ibig sabihin nito? So, the deletion of data is equivalent to the destruction of a corporeal thing. It destroys them or makes the computer data unrecognizable. So, hindi lang ibig sabihin na nawala yung data interference, yung computer data for there to be a data interference. Pwede ding the computer data was modified or altered in such a way that it is unrecognizable or hindi mo na magamit yung computer data. So, this data interference talks about any unauthorized action that prevents or terminates the availability and authenticity of the data to the person who has access to the computer or the data carrier on which it was stored. So the term alteration means the modification of existing data. So, ang very good example of data interference is if there is an unauthorized encryption of your data, preventing the owner of that computer data to access and use your computer data because it is encrypted at hindi mo alam how to decrypt it. Okay, so what are the key points when we talk about data interference? First, the data interference must be without right. So, the owner of the computer data or the electronic document, hindi niya binigyan ng authority yung tao na nag-interfere or nag-modify doon sa computer data. It was done with intent or can be also done recklessly. There should be an alteration, damaging, deletion, or deterioration of the computer data, and it can also be done by the introduction or transmission of viruses. Okay, what is the aim of this provision? The aim of the provision on data interference is to provide computer data and computer programs with protection similar to that enjoyed by corporeal objects against intentional infliction of damage. The protected legal interest here is the integrity of the proper functioning of use of stored computer data or computer programs. So this provision seeks to protect the integrity of computer data, electronic document, or electronic data message. Now let's go to another type of CIA offenses, which is system interference. In system interference, the offender intentionally alters or recklessly hinders or interferes with the functioning of a computer or computer network by first inputting, altering, suppressing, transmitting, deteriorating, deleting, or damaging computer data or program, electronic document or data message, including the introduction of virus. And such alteration, hindering, or interference is without right or authority. So, if you would read into the provisions, parang parehas lang with data interference. But what are the key points that we should remember when we are talking about system interference? So, system interference is referred to as computer sabotage, and this provision aims at criminalizing the intentional hindering of the lawful use of computer systems, including telecommunications facilities, by serious or influencing computer data. So, to differentiate data interference and system interference, ang titignan natin would be the seriousness of the effect. So, number one, data interference siya kapag ang minodify, ang inalter, or ang na-damage is a computer data. But even if It is the computer data. It is a computer data that was altered, hindered, or interfered with, but the effect is very serious, such that it also, the hindering of the computer data affects the whole computer system. It would amount to system interference. So, ang main difference would be the seriousness of the effect. Okay? Next would be the system interference. Ang main rationale between in system interference is to protect the interest of operators and users of computer or telecommunication systems, being able to have them function properly. So, what we are contemplating in system interference vis-a-vis a data interference is kapag system interference, malaking we are talking about a computer system, or we are talking about a bigger facility. For example, telecommunications system or telecommunications facility, whose functions was altered and interfered in such a way na it is not functioning properly. So that is called system interference. And of course, we should remember that such interference should be without right. It could be done with intent. It should be done with intent, or can also be done through recklessness. Pwede din siyang, it can also be committed by the introduction or transmission of viruses. So, ang isang good example would be illegally encrypting the computer system in a computer system in such a way that you would hinder the owner of that computer system to function properly. Okay, let's now go to the last cybercrime offense under the CIA offense type, which is misuse of devices. So, in misuse of the provision on misuse of devices covers the use, production, sale, procurement, importation, distribution, or otherwise making available without right a device, including a computer program, designed or adapted primarily for purpose of committing any offenses under RA 10175, or making available without right of a computer password, access code, or similar data by which the whole or any part of a computer system is capable of being accessed for the purpose of committing any of the offenses under RA 10175. So that is the first way on how you could commit a misuse of device. The second way on how you could commit a misuse of device would be the possession of a device, including a computer program, or the possession of a computer password, access code, or similar data, by which the whole or any part of a computer system is capable of being accessed for the purpose of committing any of the offenses under Section 4 of RA 10175. So, you commit the misuse of device by first making the device or the computer password, the computer program available. You use it, you produce it, you procure it, you cause the importation and its distribution. That's the first way of committing misuse of device, making these items available. Number 2 is the possession of these items without legal authority. Okay. And there must also be the intention to use this device in the commission of any of the cybercrime offenses provided in the cybercrime law. When we say distribution, what are we talking about? So it may cover the active act of the forwarding data to others, making it, for example, making devices or hyperlinks, illegal hyperlinks available online for the use of others. And when we talk about making available computer program, ang kadalasan ang tinutukoy ng mga computer program dito would be programs to, for example, designed to alter or even destroy data or interfere with the operation of systems such as virus programs or programs designed or adapted to gain access to computer systems. So, for example, kung ikaw a hacker for example had access, yung isang hacker, he made his tools available online for distribution or for use of other persons. This computer making available this illegal computer programs amounts to a violation of the provision on misuse of device under the cybercrime law. Okay. We still have one CIA offense, and that is cyber squatting. Cyber squatting is the acquisition of a domain name over in the internet, and the acquisition is in bad faith to profit, mislead, destroy reputation, and deprive others from registering the same if such domain name is first similar, identical, or confusingly similar to an existing trademark, or it is identical or in any way similar with the name of a person other than the registrant in case of a personal name, and the domain name, the acquisition of the domain name is without right or with intellectual property interest in it. So, ano ba yung domain name? So, you can look at the presentation. The domain name is often the website name or the host name. So makikita nyo, for example, in the given domain, the domain name would be the philippineairlines.com, and domain names are basically based on who owns it. So there would be cyber squatting, for example, any person who registered, for example, yung domain name kanina, Philippine Airlines. So, any person who other than Philippine Airlines, kapag ni-register nila yung domain name na yon in bad faith, they acquired the domain name, they paid for the domain name in order with the intention to profit, mislead, or destroy their reputation or deprive Philippine Airlines from registering the same, there is a violation of the provision on cyber squatting. So, for example, ano ba tong mga domain name na hindi mo pwedeng i-register in bad faith? First would be any domain name, any name which is similar or identical or confusingly similar to an existing trademark. So, pag ganito, you would check with the Intellectual Property Office kung what are the trademark registered. So that's what you could do to check whether there is an existing trademark on this name. Next is similar, identical with the name of a person. Like for example, kung a true to life example is there was someone who registered in bad faith the domain name www.laurenlegarda.com. So the perpetrator registered this domain name and tried to sell this to Senator Lauren Legarda. So in that, makikita natin yung elements. The name is the name of a person, and in this example, it is name of a known person of the Senator Lauren Legarda. It was acquired in bad faith because it was acquired to profit. Diba? Tinry niyang ibenta kay Senator Lauren Legarda yung domain name. So, since that person, the perpetrator, registered the domain name Lauren Legarda, it also deprived others, especially the one who was right to register this, si Senator Lauren Legarda, from registering the same and used the same. Okay, so that is cyber squatting, when you acquire a domain name in bad faith, and your intention is to profit, mislead, destroy reputation, or deprive others from registering the same. Pwede din, meron dito yung they would be registering a domain name in order to in order to use the good reputation of a known company, for example, for its own interest. So, to mislead others. So, ginagamit niya yung isang domain name, yung pangalan ng isang known trademark, para yung mga bumibili or pupunta doon sa domain name na yon, sa website na yon, akala nila the products that are sold in that website are the products of the company that has existing trademark, for example. So, ang example dito is, for example, ang www.nike.com, hindi pa siya registered. So, there's someone who registered www.nike.com at nagbebenta ng sapatos na doon. And yung nag-register noong domain na yon, he registered it in bad faith, at ang kanyang main agenda is para i-mislead yung public or yung mga bibili or pupunta sa website niya na yung mga products niya are Nike products, 'di ba? So he's just using the good reputation of someone who is known in the industry of producing shoes for his own, gagamitin niya yung good reputation na yun ng Nike for his own interest. Okay, let's now go to the second type of cybercrime offenses, which are computer-related offenses. So there are 3 computer-related offenses. These are computer-related forgery, computer-related fraud, and computer-related identity theft. So first, what is computer-related forgery? Computer-related forgery is the input, alteration, or deletion of any computer data without right, resulting in inauthentic data with the intent that it can be considered or acted upon for legal purposes as if it were authentic, regardless to whether or not the data is directly readable and intelligible. And the act of knowingly using computer data, which is the product of computer-related forgery as defined in the law for the purpose of perpetrating a fraudulent or dishonest design. So the purpose of the provision on computer-related forgery is to create a parallel offense to the forgery of tangible documents. So, reading the provisions of computer-related forgery, mapapansin natin that there are 2 ways on how to commit computer-related forgery. So, the first way of committing computer-related forgery, you look at the presentation, would be inputting, altering, or deleting computer data with the intent that it be acted upon for a legal purpose as if it is authentic. And this act of inputting, altering, and deleting computer data is without right. So that's the first way. Kapag meron kang finorge na computer data, diba? That's the first way. The second way is there is a forged computer data, there is a forged electronic document, and you know about the fact that what you have in your possession is the forged computer data, and you knowingly and intentionally used this forged computer data to perpetrate fraud. Okay. So, let's give a concrete example. For example, there is an electronic document, an electronic data, and the data in that electronic document contains the beneficiary, the name of a beneficiary of an award, and nakalagay din doon yung kanyang bank details. And then, someone inputs or alters the bank account provided in that electronic document, provided in that computer data, in such a way that, based on that said inauthentic, in such a way that yung bagong bank account na napunta na nandoon is the bank account of another person, the bank account, for example, of the perpetrator. Based on the said inauthentic data, the person who received it went to the bank and deposited the money to the bank account of the perpetrator. Kasi nga si perpetrator, pinalitan niya yung details doon sa electronic document na yon, resulting to the inauthentic data. So, that's the first way on how to commit computer-related forgery, the altering or inputting any data doon sa computer data, doon sa electronic document. Next, what if there is iba yung nag-alter ng computer data at yung tao na nakakita doon sa computer data nun with the knowledge that it is a forged it is a forged computer data, ginamit niya yung computer data na yon in order to perpetrate fraud. For example, a fraud is para magkaroon siya ng property interest or magkaroon siya ng pera na hindi dapat sa kanya. That person who knowingly used the forged electronic document or forged computer data is also liable for computer-related forgery. Okay. It is not necessary that a damage has been created in order for it to amount to computer-related forgery. The fact that you forged the computer data, may inalter ka doon sa computer data, that itself, you, even without any damage, kahit na hindi pa nakapag-deposit doon sa bank account na nilagay mo, kahit wala pang deposit na nangyari, you can still be liable for computer-related fraud. But kapag may damage, mas mataas yung penalty. So, it may or may not result in damage. Kapag nagkaroon lang ng damage, the penalty is higher compared to that kapag walang damage na there is no damage as a result of the computer-related forgery. Now, let's go to the computer-related fraud. The computer-related fraud is committed when the offender, without authority to do so and with fraudulent intent, either inputs, alters, deletes computer data or program, or interferes with the functioning of a computer system, and such altering, inputting, and deletion or interference in the functioning of a computer system may or may not result in damage to another. So, computer-related fraud, it is committed without right by altering, inputting, or deleting computer data or computer program. So, how do we contextualize computer-related fraud? Ngayon kasi with all the technology, with all the new technology, assets are often represented or administered in computer system. Nandito na yung GCash, online transfers, e-funds, e-deposits, and because of this way of administering your assets, it has become targets of manipulation. So the intention of the provision on computer-related fraud, it was enacted against undue input manipulation in the course of data processing with the intention to effect an illegal transfer of property. So, ano yung mga kadalasang cases of computer-related fraud na nakukuha natin? For example, a phishing email. If you are familiar with phishing email. So, you receive a phishing email and it contains a link directing you to a fraudulent page where you are required to input your personal information. And as such, yung iyong assets, by inputting those personal information in the fraudulent link provided in the phishing email, the perpetrator would be able to administer or would be able to make illegal transfer of your funds sa iyong bank accounts. For example, another example is, yung makikita nyo doon sa example is, in the picture is assets or money in the form of your load. Diba? You are manipulated to enter or to input that the details as provided in the SMS, tapos magkakaroon ng illegal transfer of load. This load is considered property, diba? It's money. So there is an illegal transfer of property because of the fraud that was perpetrated against you. So yeah, the most commonly, especially ngayong ngayong COVID-19 pandemic, ang most common na computer-related fraud incidents na i-report sa ACG and the NBICCD is that of phishing emails. So kapag nakatanggap ka ng phishing email, kadalasan ang violation mo doon, we file a case of not only computer-related fraud for the illegal transfer for the fraud perpetrated with the intent to make an illegal transfer of property, pero meron ding, we also file computer-related forgery. Why? Because kadalasan yung ginagamit nilang template, phishing email would be a template of a legitimate bank, like for example your known banks, BPI, BDO. So they're using the template of these known banks, of this banking institution, and they alter the computer data therein. So in addition to computer related fraud, we also file computer related forgery against the perpetrators na nahuhuli. Now, let's go to another type of computer-related offense, which is computer-related identity theft. In computer-related identity theft, the offender intentionally acquires, uses, misuses, transfers, possesses, alters, or deletes identifying information belonging to another, and the acquisition and use or possession of this person identifying information is done without right or consent from the person to whom the personal information belongs. And the computer-related identity, the acts provided under the provision of computer-related identity theft may or may not result in damage. So, ano yung mga acts, how to commit this computer-related identity theft? If one intentionally acquires this identifying information, uses this identifying information, or misuses or possesses this identifying information without legal justification, and this identifying information does not belong to you, hindi sa'yo. So, there is a commission of computer-related identity theft. So, identity theft, computer-related identity theft happens when someone steals your personal information, and most commonly, they steal your personal information to commit fraud or to commit illegal transfer of money madalas. The identity thief may use your information to fraudulently apply for credit or other pecuniary advantages. These acts can damage your credit status and cost you and your money, and cost you time and money to restore your good name. So, kadalasan paano ba na nakukumit tong computer-related identity theft? When we received emails, for example, purporting to be an email from someone, they use your identifying information and for them to apply for credit or take pecuniary advantages. For example, they use that is tantamount to committing computer-related identity theft. And even the simple act of acquiring this identifying information would be computer-related identity theft. So, for example, yung mga tao na who uses public Wi-Fi, and sometimes other people would try to harvest the personal and identifying information na ini-input nung mga internet users while using public Wi-Fi. So that act can be considered computer-related identity theft because even the act of acquiring this identifying information without right, it is tantamount to computer-related identity theft. Hindi necessary na nagamit mo na or you cause damage. The mere act of acquiring without authority this identifying information is considered illegal under the provisions of computer-related identity theft. So, what are these personal identifying information? Let's use the definition under the Data Privacy Act of 2012. So this personal information refers to any information, whether recorded in a material form or not, from which the identity of an individual is apparent or can be reasonably and directly ascertained by the entity holding the information, or when put together with other information would directly and certainly identify an individual. Okay, let's go to the third type of cybercrime offenses, and that would be the content-related offenses. There are three types of three content-related offenses. These are cyber sex, online child abuse, child pornography, and cyber libel. So the bulk of the cybercrime reports na nakukuha ng ating mga law enforcement authorities would be this on cyber libel. So, karamihan din ng mga cybercrime cases filed in court, amounting I think to around 45% of the cases filed in court, kadalasan cyber libel. Ang cyber libel yung kaso. Okay, what is cyber sex? The first kind of content-related cybercrime offense. Cyber sex, it is the willful engagement, maintenance, control, or operation, directly or indirectly, of any lascivious exhibition of sexual organs or sexual activity. The act was done with the aid of a computer system, and the act was done for favor or consideration. So in the case of Dicini versus Secretary of Justice, the Supreme Court discussed that cyber sex is interactive prostitution by webcam. So it applies only to persons engaged in the business of maintaining, controlling, or operating directly or indirectly the exhibition of sexual organs or sexual activity with the aid of a computer system. So when the constitutionality of the cybercrime law was challenged, ang sinabi nila on the provision of cyber sex is that it deprives ordinary people from engaging from this type of activity. Like for example, ayun nga, yung lascivious exhibition online. Paano naman daw if it's for their personal consumption? Would it be tantamount to a violation of the cybercrime law? It was clarified by the Supreme Court that magiging punishable lang siya. It is a violation of the cyber sex provision if it is interactive prostitution or the lascivious exhibition of sexual organ or sexual activity was done by a person engaged in the business of maintaining, controlling, or operating these types of business. So pag hindi siya business, hindi siya and it was done personally, hindi siya tantamount to a violation of the cyber sex provision. Kadalasan kapag yung ganitong activity, illegal activity, kapag ginagawang business yung cyber sex, yung ating law enforcement authorities, they charge the person under the anti-human trafficking law of the Philippines. Sa human trafficking law, and cybersex 10175. Next would be the content-related offense would be child pornography, which constitutes the commission of any of the punishable acts under RA 9775 or the Anti-Child Pornography Act of 2009 when committed through a computer system. So under the Cybercrime Prevention Act 10175, it provides that the penalty to be imposed shall be 1 degree higher than that provided in Republic Act number 9775. It was clarified also in the Decini case that because now if there was a commission of online child pornography, you can charge the perpetrator in two laws. First is under the Child Pornography Act, yung 9775, and ngayon provided under 10175, yung that any acts provided under child pornography when committed in cyberspace or with the use of a computer system, pwede mo din siyang i-charged under the provision of child pornography under 10175. Kinlarify ng Supreme Court doon sa Decini versus Secretary of Justice case that an accused charged under this section can no longer be charged for violation under the provision of 9775 because kapag nagkaroon ng dalawang charged under 9775 and 10175 is that there would be a violation of, there would be double jeopardy. So, kailangan yung ating law enforcement officers pumili kung saan nila i-charge yung perpetrator, either under the child pornography law or 10175 or under cybercrime law. Ang effect lang is that if you would charge the person under 10175, the penalty would be 1 degree higher than that provided under 9775. This is expressly provided under the cybercrime law. Okay, next, let's go to the most controversial cybercrime offense, which is cyber libel. So, the RA 10175 in defining cyber libel made reference to the unlawful or prohibited acts of libel as defined under Article 355 of the Revised Penal Code as amended. It's just that the act considered as libel under Article 355, in order for it to be considered as cyber libel, it should be committed through a computer system or any other similar means which may be devised in the future. So, when committed through computer system, for example, kapag yun nga, pinost sa Facebook, ginamitan mo ng internet, 'di ba? So, this with the use of information and communications technology, it now amounts to cyber libel. But technically, all the elements for cyber libel, ang sinusunod pa din natin is yung traditional definition under the Article 355 of the RPC. Ang added element lang would be it was committed through the use of computer system. Kaya, naging cyber libel. So, what is cyber libel in Article 355? It is any public and malicious imputation of a crime or of a device or defect, real or imaginary, or any act, omission, condition, status, or circumstance tending to discredit or cause the dishonor or contempt of a natural or juridical person or to blacken the memory of the one who is dead. And so, that's the traditional definition of libel. So, yun pa din yung cyber libel, that same act. It's just that kapag cyber libel, it was committed through a computer system. Or kadalasan ngayon kapag yung libelous statements, instead na nabasa mo sa newspaper, it is now published sa internet or pinost ng perpetrator sa kanyang Facebook account. Okay. In the case of Decini versus Secretary of Justice, sinabi doon that cyber libel is not a new crime since the revised penal code already punishes it. So, in effect, the provision on cyber libel in 10175 merely affirms that online definition constitutes similar means for committing libel. And it was also clarified there that only the author of the libelous statement or article is penalized. So, kung sino lang yung person na nag-post nung libelous statement, siya lang ang liable for violation of the cyber libel provision. Yung mga taong nag-like, tsaka nag-comment, hindi sila liable for cyber libel. Maliban if yung comment nung isa sa mga yung comment ng mga tao, yung comment ng isang tao doon sa libelous statement na pinost sa internet, which is also tantamount to a libelous statement. Okay? So, yung pagla-like ng isang libelous statement, it is not considered cyber libel. Yung mere pagko-comment, hindi ka din magiging liable mere pagko-comment sa isang libelous statement, hindi ka din magiging liable for cyber libel maliban kung yung comment mo mismo it is libelous also. So you would be violating the provision of cyber libel not because of commenting but because of the libelous nature of the comment that you put. Okay. Next, Section 5 of RA 10175 also provides for other cybercrime offenses, and these are first, aiding or abetting in the commission of cybercrime. So, any person who willfully abets or aids in the commission of any of the offenses enumerated in the cybercrime law shall be liable for aiding or abetting in the commission of cybercrime. And any attempt in the commission of cybercrime is also punishable. However, the crime of aiding and abetting and attempt in the commission of cyber libel and online child pornography is not permitted as provided in the Dicini versus SOJ decision. Okay, let's now go to Section 6 of 10175, which is a catch-all provision. Ito yung in-explain ko sa inyo dati. Kanina na sinabi ko, all crimes defined and penalized by the revised penal code and other special laws. So, yung mga traditional crimes na provided sa ating RPC at special penal laws, if they were committed by or through or with the use of information and communications technology, Section 6 of 10175 provides that the penalty to be imposed shall be 1 degree higher than that provided by the law penalizing the same. So, ang mangyayari kapag yung commission ng nung mga crimes under the RPC and the special laws, it was committed using information and communications technology by virtue of Section 6 of RA 10175, yung penalty is 1 degree higher than the penalty provided in the RPC and the penal code. Okay, what is the jurisdiction of cybercrime offenses as provided in the law? So, all cybercrime cases, yung mga diniscuss natin kanina, the violations of the RA 10175 shall be filed with the regional trial court. And the regional trial court in the Philippines will have jurisdiction if the violation of the law if the violation is committed by first in the Philippines. So, regardless kung ano yung nationality ng perpetrator, if the act was committed in the Philippines, pwede tayong magkaroon ng jurisdiction. And if the cybercrime offense was committed by a Filipino national, regardless of the place of commission. So, kahit na he perpetrated the crime outside of the Philippines, but he is a Filipino national, yung ating courts dito, we can have jurisdiction. Or if the cybercrime offense was committed with the use of any computer system wholly or partially situated in the Philippines, or when by such commission any damage is caused to a natural or juridical person who at the time the offense was committed was here in the Philippines. Okay, Now let's go to the last part, to the last slide of the first part of this session. Who are the law enforcement agencies under RA 10175? So under Section 10 of the law, the National Bureau of Investigation and the Philippine National Police shall be responsible for the efficient and effective law enforcement of the provisions of the cybercrime law. The NBI and the PNP shall organize a cybercrime unit or center manned by special investigators to exclusively handle cases involving violations of the cybercrime law. So the NBI and the PNP already established their cybercrime units. For the Philippine National Police, it is the Anti-Cybercrime Group. They also have regional offices. And for the NBI, it is the Cybercrime Division naman, yung kanilang cybercrime unit or specialized unit handling cybercrime cases. Okay, so that's it for the first part of this session. So before we proceed to the second part of our session, let me first give you a trivia about RA 10175. So when the law was passed in 2012, several petitions challenged the constitutionality of the cybercrime law. However, in the case Dicini versus Secretary of Justice, the Supreme Court upheld the constitutionality of the law, but the said decision rendered some provisions of the law as unconstitutional. So, what are these provisions that were rendered unconstitutional? So, deemed hindi na sila part ng law. First would be on Section 4C3 on unsolicited commercial communications. So itong section na to, this was rendered unconstitutional. Next would be Section 5, aiding or abetting or attempt in the commission of cybercrime in relation to cyber libel and online child pornography. Ito yung na-discuss natin kanina nung sinabi ko na in relation to libel and online child pornography, walang aiding or abetting or attempt in the commission of these said crimes. Next would be Section 12 on real-time collection of traffic data and Section 19 on the restricting or blocking access to computer data. So if you get a copy of RA 10175, puntahan nyo tong mga provisions na to and cross them out, okay? Para hindi tayo magkamali. So I suggest that for a better and deeper understanding of the cybercrime law, you, after this lecture, you get a copy and read the full text of RA 10175, the rule on cybercrime warrants, and the Supreme Court decision in the case of Dicini versus Secretary of Justice. Yung GR number, itype nyo lang sa internet. You can download it from there. Okay. Now, let's go to the second part of our session, which is the cybercrime warrants. So, the cybercrime warrants are provided under the cybercrime law and also provided under the rule on cybercrime warrants promulgated by the Supreme Court. So the legal framework of when looking the legal framework in relation to the rule of cybercrime warrants would be the same. The Electronic Commerce Act, the rules on electronic evidence promulgated by the Supreme Court. We have the Cybercrime Prevention Act of 2012 and the rule on cybercrime warrants, which was promulgated by the Supreme Court recently, 2018 pa lang. Okay. Now let's go to the scope and applicability of the rule on cybercrime warrants. So the rule on cybercrime warrant sets for the procedure for the application and grant of warrants and related orders involving the preservation, disclosure, interception, search, seizure, and or examination, as well as custody and destruction of computer data as provided under RA 10175. So since it is expressly provided that the scope and applicability of the rule covers computer data, it is relevant for us to give a definition what is a computer data. So a computer data refers to any representation of facts, information, or concepts in a form suitable for processing in the computer system, including a program suitable to cause a computer system to perform a function, and includes electronic documents and or electronic messages, whether stored in a local computer systems or online. So I would just want to clarify that this rule, the scope and applicability of the rule on cybercrime warrants, is not only limited when you are investigating cybercrime or cyber-related offense. So if the rules also apply when the law enforcement authorities are investigating non-cybercrime cases, but which entail the use of electronic evidence or of computer data. For example, if there is a traditional crime, like for example murder, and you need to examine a computer or you need to examine a cell phone. So before you would examine or before you would search, seize, and examine the computer or the cell phone and it's the computer data therein, you need to apply for a warrant for the a cyber warrant, search, seizure, and examination of computer data. Because, yun nga, the rule on cybercrime warrant applies for the application for the preservation, disclosure, interception, search, seizure, and examination, as well as custody and destruction of computer data. Okay? So, for example, kadalasan if PDEA is investigating for example, if PDEA is investigating a drugs case and if it involves online transaction or it involves kailangan ng the evidence or in a cell phone or in the computer, kahit na hindi cybercrime yung case na iniimbestigahan but entails the use of electronic evidence such as the computer data or the communication involved in the computer, kailangan pa din mag-apply ng cybercrime warrant. Okay. So what are the types of computer data which is the subject of the cybercrime warrants that we are investigating? So there are three types of computer data. These are three types or classifications of computer data. So number one would be subscriber information, or it refers to any information that is held by a service provider relating to the subscribers of its services other than traffic or content data. Yan, makikita nyo from my presentation. For example, Facebook is a service provider, right? So, subscriber information would refer to the name, email address, gender, birthday, and other subscriber information na pinoprovide noong subscriber ng service na pinoprovide ni Facebook. Like for example, when we are creating our account, si Facebook tatanungin tayo ng mga information before we would be able to make an account. So this information that we are providing, these are called subscriber information. So that's the first type of computer data. Next would be traffic or non-content data, or it refers to any computer data other than the content of the communication, which is usually computer generated. So kadalasan ang traffic data or non-content data would be, for example, an email, a Gmail. You receive a Gmail, makikita nyo yan doon sa header, dun sa email header, who's the recipient, who's the sender, the date of the sending, and receipt of the email, the IP address of the sender and of the receiver. Tapos information of what type of computer data, kung anong sinend, was it a video, was it a picture. Ito yung mga traffic or content data. traffic or non-content data. Okay, the third classification of computer data would be content data. Refers to the contents of the communication. So, ito na yung, for example, in a Facebook Messenger or for example, Gmail. In a Gmail account, yung mga emails mo, the contents, the communication therein, contents of the communication, yun yung sinasabi nating content data. Okay, to put everything in a perspective, I'll give you an example. For example, we are investigating a case of child pornography, of online child pornography. So, there was a distribution of child pornography using Facebook. Pag mag-iimbestiga tayo, una nating titignan would be, hihingi tayo ng computer data, subscriber information kay Facebook. Tatanungin natin si Facebook, sino ba itong subscriber na ito? Give us the information, the subscriber information of this Facebook account. So, ibibigay sa atin ang first name, the last name, the email address, the gender, the birthday provided by the person, the owner of that Facebook account. And then, pwede din nating, as to traffic data, pwede nating tanungin si Facebook. Facebook, ano ang IP address nitong Facebook account na to? Please provide us the details. Ano yung mga iba niyang communication? Sino yung kadalasan niyang kausap or the recipient? What's the date of sending? Ano yung mga sinisend niya na mga contents? Are the videos ba, text, or pictures? And pwede din nating hingin yung content data, yung kanyang communication. Like for example, kung nag-distribute siya ng child pornography, pwede nating hingin kay Facebook, can you give us his communication, the computer data, the content data, his communication when he distributed these child pornographic images or videos. So, ganon. These are the types of computer data. Okay, before we go to a discussion of what are the cybercrime warrants, let's first discuss one of the most relevant provisions in the rule on cybercrime warrant as well as in the cybercrime law, which is the preservation of computer data. So, what is preservation of the computer data? Preservation is the activity that keeps stored data secure and safe. Preservation request order is an order from the LEAS mandating the service providers to keep, preserve, and maintain the integrity of a computer data subject thereof. It is a condition sine qua non before an application for a cybercrime warrant may be filed in court. Bakit kailangan natin ng preservation of content data? Because for example, a Facebook account, or sabihin na lang natin the subscriber information of a Globe user, of a Globe Telecom user. Kailangan natin ng kanyang subscriber information. Si Globe or si Facebook, under our law, they are only required to preserve subscriber information and traffic data for a minimum of 6 months from the date of transaction. So, in order for us to be sure that the computer data, the subscriber information, and the traffic data is kept, is preserved, and its integrity is maintained, kailangan mag-serve ng ating law enforcement authorities kay Globe or kay Facebook ng preservation order, requesting them to preserve the information or the computer data that we are requesting. So, if you can look at the presentation under our law, kapag subscriber information and traffic data, ang ating mga service providers, they are required to automatically preserve these types of computer data for a minimum of 6 months. from the date of transaction. So this is their legal obligation. Kahit walang preservation order, they are required by law to preserve. For content data, they are also required to preserve content data for 6 months from the date of the receipt of the order from the LEAS requiring the preservation of the content data. So, i-clear ko lang, pag preservation of the computer data, the service providers, even without the order from the law enforcement authority, meron silang obligation to preserve subscriber information and traffic data. Content data, wala silang obligation to preserve content data, but once they are served with the preservation request or preservation order from law enforcement authority, they will have the obligation to preserve this content data for 6 months from the date of receipt of the said preservation order from the LEAS. Okay. After ang preservation order, hindi kailangan ng cybercrime warrant. Si PNP and si NBI, they can serve this doon sa service provider or doon sa kung sinong holder ng computer data even without a warrant. Because, bakit? Because ang preservation order is just an order to request the computer data that you are holding. Iba pa yung disclosure. So when you send a preservation order or preservation request, hindi pa nila ibibigay sa iyo yung kailangan mong computer data. You are just asking them to preserve para kung nakakuha ka na ng disclosure ng warrant for disclosure, sure ka na yung computer data na hawak nila andun pa, it's available, its integrity is preserved. Okay? Alright, so paano to ginagawa ng law enforcement authorities natin? They served a preservation request and preservation order and serve it to the service provider or to the holder of the computer data. So, the one-time extension of 6 months upon the order of the law enforcement authority is given under the rule on cybercrime warrants. But once computer data is preserved, remember sinabi ko kanina, they are only required to preserve it for 6 months with an one-time extension of 6 months. But if the computer data preserved is used as evidence in case, the receipt by the service provider of the transmittal document to the from the prosecution shall be deemed a notification to preserve computer data until final termination of the case or as ordered by the court. Okay. So what are the types of cybercrime warrant? The types of cybercrime warrants would be warrant for the disclosure of computer data, warrant for interception of computer data, warrant for the search, seizure, and examination of computer data, and warrant for the examination of computer data. So these warrants are based on the procedural provisions of the cybercrime law, which provide law enforcement authorities with technical tools that will aid them in conducting cybercrime and cyber-related investigations. So, I'll give you again a general overview of the preservation order and warrants. So, tulad nung sinabi ko kanina, there is a child pornography case. Ang una mong gagawin, if you know that, if meron you have information na itong FB account na ito yung nag-distribute ng child pornographic, child exploitation materials or child pornographic materials. Ang una mong gagawin is to send Facebook or send Globe preservation order asking them to preserve the subscriber information, the traffic data, and the content data in relation to this IP address, in relation to this Facebook account. Yan, preservation order. After the preservation order, you apply for a warrant for the disclosure of computer data. Kasi nga, as I said, the preservation, ipapreserve lang nila yung computer data na kailangan mo for the investigation. But it does not merit for the disclosure. Kailangan mo ng warrant para yung pinreserve na data is makuha mo. So later we would discuss about the warrant for interception of computer data and warrant for the search, seizure, and examination of computer data. As an overview, yung warrant for the search, seizure, and examination of computer data, ito yung kapag it's a typical search warrant, but however, the subject would be computer systems and computer data. So it entails for you to search a house, seize the computers there, and examine the computers and the computer data in those computers. Okay, on the other hand, the warrant for examination of computer data as an overview would be kapag you are legally in possession of a computer and you want to examine the computer data inside that computer. Before you can do that, you need to apply for a warrant for the examination of computer data. Okay, where to file an application for cybercrime warrants? Kapag ang case na iniimbestigahan mo is under Section 4 and Section 5 of 10175. Ito yung mga cybercrime offenses. Yung sinabi ko, yung CIA offenses, the computer-related offenses, and content-related offenses. Tapos yung aiding and abetting and yung attempt to commit this cybercrime offenses. If-file mo yung application for the cybercrime warrants sa cybercrime courts. But if what you are investigating are traditional crimes or those provided under the revised penal code and special penal laws in relation to Section 6, or if it's a traditional crime na gagamitan mo ng electronic evidence, you would file it in regular courts or specialized courts, pwedeng drugs courts or family courts or environmental courts. But if you want if the warrant is to be enforceable outside of the Philippines or nationwide, there are cybercrime courts that are authorized to issue warrants that are enforceable nationwide and outside of the Philippines. So for example, yung warrant na kukunin mo would be served from Facebook, which is a foreign entity. Kailangan mong apply ng warrant sa cybercrime courts either in Quezon City, Manila, Makati, Pasig, Cebu, Davao, and Cagayan de Oro, because these are the cybercrime courts that are whose warrants that were issued can be enforceable outside of the Philippines. Okay, who are the cyber warrant applicants? So under the rule on cybercrime warrants, it is the law enforcement authorities, the PN, who can apply for the issuance of cybercrime warrants. However, nothing in the rule on cybercrime warrants prohibit the prosecutors in case the case or action is already filed in court. So pag ganon, nothing prohibits them to apply for the said cybercrime warrants through the filing of a motion. Okay, what are the contents of an application for a warrant? General contents. In order for these warrants to be issued kasi, you need to file an application in the appropriate court. Yung discuss natin kanina, ano ba yung appropriate court? So the following, as you can see on your screen, are the general requirements that must be contained in your application. So you should provide what is the probable offense involved in relation to the investigation that you are doing, the relevance and necessity of the computer data sought to be disclosed, vis-a-vis the purpose of your investigation, names of the individuals or entities whose computer data are sought to be disclosed, and including the names of those who have control, possession, and access to this computer data. So particular description of the computer data, place where the disclosure is to be enforced, or if you are applying for an application for search, seizure, and examination of computer data, placed where the this warrant for search, seizure, and examination of computer data would be enforced. So, manner or method of disclosure or implementation and other relevant information to persuade the court that there is probable cause to issue the said warrants. So, these are the general contents of the application, regardless kung ano yung kung anong types of warrant yung ina-apply mo, but this must be contained in your application. Later, we would discuss what are the other the specific contents na dapat in addition to these general requirements, kung ano pa yung kailangang ilagay. Okay. Let's now go to the types of cybercrime warrant. The first type of cybercrime warrant is the warrant for the disclosure of computer data. Sabi ko kanina, ang first step would be to issue the law enforcement authority should issue a preservation order to the service provider or to the holder of computer data. Okay, this is the preservation order is condition sine qua non. It's kailangan siya before ka makapag-apply ng warrant for the disclosure of computer data. So, warrant for the disclosure of computer data authorizes law enforcement authorities to issue an order to disclose and require any person or service provider to disclose or submit computer data in his or her possession or control. So, kapag nag-apply ka ng application for the issuance of disclosure of computer data, hindi yung warrant from the court, hindi lang yung warrant from the court ang isa-serve mo. The warrant authorizes you to issue a production order So, si Leia, mag-i-issue ng production order and isa-serve tong production order and a copy of the warrant doon sa service provider or to that person who is in possession of the computer data. So, compliance should be within 72 hours from the receipt of the said order. So, the service provider or the holder of the computer data, kapag na-servan sila nitong disclosure of computer data and nung production order, kailangan mag-comply sila within 72 hours from receipt of the said order. So, these are the contents of the application and the supporting affidavits. Yeah, it is listed there. You can also read this from the rule on cybercrime warrants. So, after you were issued the warrant for the disclosure of computer data, you are required within 48 hours from implementation of the said warrant or after the expiration of the effectivity of the said warrants, you are required to make a return on the disclosure of computer data. So you will file a return to the court that issued the said warrant. So law enforcement authorities are allowed to retain a copy of the disclosed computer data subject of the WDCD if it would be used for case build-up and preliminary investigation, and it should be kept confidential and labeled as retained copy. So, next type of cybercrime warrant would be warrant for the interception of computer data. Ano ba ang ino-authorize? When you apply for, if you are issued a warrant for the interception of computer data, ano yung pwede mong gawin? It authorizes law enforcement authorities to carry out any of the following activities: listening, recording, monitoring, and surveillance of the content of communications, including procuring of the content of computer data. So, said activities are conducted either directly or indirectly through access and use of a computer system, or indirectly through the use of electronic eavesdropping or tapping devices at the same time that the communication is occurring. So, sabi ko kanina, when we say interception, the communication is occurring. So, if you want to intercept the communication, if you want to lawfully intercept a communication in relation to an investigation of a case, kailangan mong mag-apply ng warrant for the interception of the computer data. Okay? If ginawa mo to and wala kang warrant, if you do it without right, as we discussed at the first part of this session, you may be liable for a violation of the provision of illegal interception under RA 10175. So, what if the communication, tapos na yung communication and you want to get a copy of that communication? Kasi you see from the presentation, sabi it's underlined, if you want to eavesdrop or make an interception at the same time that the communication is occurring, what if the after na ng communication, ibang warrant na yung i-apply mo? So, if yung communication, ang may possession would be the service provider, what you would apply is the warrant for the disclosure. You need to preserve that computer data and apply for a warrant for disclosure of computer data. Or kapag yung communication is it's stored in the computer of the perpetrator, yung accused, you need to apply for the warrant for the search, seizure, and examination of the computer data nung perpetrator. Okay, so contents of the application for WICD, same as the application for the warrant for the disclosure of computer data, except that the subject matter is the computer data, subject matter of the communication sought to be intercepted. Okay, next type of, if you are issued a warrant for the interception of computer data, you are also required to make a return within 48 hours from implementation or after the expiration of the effectivity of the said warrant. So, notice you are also required that within 30 days from the filing of the return or from the lapse of the 48-hour period to file a return, the law enforcement authority has the duty to notify the person whose communication or computer data has been intercepted. Kailangan i-inform mo yung tao whose communication was intercepted about the fact that his communication was intercepted. And within 10 days from the receipt of the notice, the person may challenge by motion the legality of the said interception. Okay, the third type of cybercrime warrant is the warrant for the search, seizure, and examination of computer data. It authorizes law enforcement authorities to search a particular place for items to be seized and or examined. So it allows the conduct of both physical and virtual search. So once issued, if you are issued with warrant for the search, seizure, and examination of computer data, interception, yung na-discuss natin kanina, may also be conducted without the need of a separate warrant for such purpose. Period to examine the computer and the computer data that were seized would be fixed by court, which may not be extended not exceeding 30 days upon motion for justifiable reasons. Okay, so what are the contents of the application of WSS-ECD? Same as in the applications for the WDCD, except that the subject matter is the computer data sought to be searched, seized, and examined, and all items related thereto. So in addition to the said requirements, you are required to make an explanation of the search and seizure strategy to be implemented, including a projection whether or not an off-site or an on-site search will be conducted, taking into account the nature of the computer data, the security features of the computer system, and other relevant circumstances if such information is available. Okay. When you are implementing a warrant for the search, seizure, and examination of computer data, the general rule is that the LEAs must endeavor to conduct an on-site search by first making a forensic image of the computer data on-site, as well as to limit their search to the place specified in the warrant. So, later in the following sessions, doon sa digital forensic analysis proper sessions, i-explain nila sa inyo how to conduct this examination, what is on-site and off-site search. But for the purpose of the rule on cybercrime warrant, let's briefly state that ang general rule when you do the forensic analysis or examination of computer data, by virtue of a search warrant, ang general rule ang examination na gagawin nyo is on-site. On-site means that you examine the computer data without the need of bringing related computer devices and or parts of the computer outside the place to be searched. So, yung examination gagawin nyo na doon sa place kung saan nyo in-enforced yung search warrant. But as an exception, if not practicable, an off-site search may be made provided that a forensic image is nevertheless made and the reason for such off-site search is stated in the initial return. So, pwede naman kayong mag-off-site search as long as gumawa kayo ng forensic image and the reason kung bakit off-site search yung ginawa nyo is stated in the initial return na ifa-file nyo sa court. When we say off-site search, it means that you would bring the computer devices and or parts of the computer system outside of the place to be searched and you would examine them. For example, in your forensic laboratory. Next, what are the allowable activities during the implementation of WSS-ECD? What are the other allowable activities? You are limited to communication and computer data that are reasonably related to the subject matter of you are allowed to make interception but limited to the communications and computer data that are reasonably related to the subject matter of the search warrant, and said activities must be fully disclosed and the foregoing relations duly explained in the initial return. And you may also order someone to provide, as is reasonable, necessary information to enable the undertaking of the search, seizure, and examination. So, for example, when you are implementing the search warrant, hindi nyo alam gamitan yung computer system, but any person there has knowledge of the functioning of the computer system. So, you are also authorized through the warrant to order that person to provide you with the necessary information to protect and preserve the computer data therein. So, next, after like in the other warrants discussed, you are also required to file an initial return on the search, seizure, and examination of the computer data within 10 days from the issuance of the WSS-ECD. So, after mo in-implement yung WSS-ECD, you are required to file an initial return where you are required to list the items that you seized, the hash value of the data stored therein, and forensic image and forensic image and of the computer data search and interception, and provide also the actions you have taken and an estimation of how long the full examination of the computer data would take place. Like for example, kasi within that 10 days from the issuance of WSS-ECD, hindi mo agad may examine lahat ng computers and computer data na na-search mo, especially kapag it's a bulk of computers and computer data. So, mag-file ka ng return, you're required to file a return and state there the estimation, gaano ba katagal gaano mo ba katagal ma-examine yung computer data. And based on this estimation, si court mag-i-issue ng period kung kailan mo dapat tapusin yung full examination of the computer data that you have searched, seized, and examined. So, on the slide, you see, after the initial return is submitted, court shall issue an order fixing the period to conclude the examination of all the items seized, which period is extendable for another period not exceeding 30 days upon motion and for justifiable reason. So, nag-file ka ng initial return na si court mag-i-issue ng order kung kailan mo dapat tapusin yung full examination of the all items seized, and yung period na binigay ni court, you can have a one-time extension of 30 days upon motion and for justifiable reason. And then after, you are required to file a final return on the search, seizure, and examination of computer data to be filed within 48 hours from the expiration of the period to complete the examination of the seized computer data. The law enforcement authority who made the final return and who made the examination must make a simultaneous turnover of the custody of the seized computer data and the communications or computer data intercepted in relation thereto. Okay. So that's the search, seizure, and examination of computer data. You apply for WSSECD. After mo ma-implement, you are required to file an initial return. After that, the court will issue an order setting the period kung kailan mo dapat tapusin yung full examination of all items seized. And this period given is extendable for not more than 30 days. And then after that, you are required to file a final return on the said warrant. So now let's go to the last type of cybercrime warrant, which is the warrant for the examination of computer data. So this warrant authorizes law enforcement authorities to conduct forensic examination on the computer data stored in a computer device or computer system, the possession of which was acquired via lawful warrantless arrest or by any other lawful means. Anong ibig sabihin nito? So as a premise, ang ibig sabihin, kapag naka-aresto kayo ng isang tao, there is a lawful warrantless arrest. Kung meron siyang mga hawak na cellphone, may computer, and that you seized incidental to such warrantless arrest or you have possession of it via lawful means, hindi nyo basta-basta pwedeng i-examine yung computer data or i-examine yung computers na na-seize nyo incidental to that warrantless arrest. Kailangan nyo munang mag-apply for a warrant for the examination of computer data. Okay? So, what are the contents of the application of WECD? Same as the application for WDCD, except that the subject matter is the computer data sought to be examined. And in addition, a disclosure of the circumstances surrounding the lawful acquisition of the computer device or computer system containing the computer data to be examined. Okay? So, hindi nyo basta-basta pwedeng i-examine yung computer device or computer data na nakuha nyo sa isang tao na you arrested via warrantless arrest. Okay? Okay, what are the other allowable activities during the implementation of WECD? So, same, you can intercept communication related to the subject matter of WECD, and you can order any person who has knowledge about the functioning of the computer system to give you necessary information to enable the undertaking of the search, seizure, and examination. Okay, what is the effective date of the said warrants? These warrants are effective for 10 days from the issuance of the cybercrime warrant. An exception, it may be extended based on justifiable reasons for a period not exceeding 10 days from the expiration of the original period. Now, ang dami nating diniscuss, what are the obligations na discuss natin? Obligation of the service provider to preserve the computer data. Obligation of the service provider to disclose the computer data pag sila ay binigyan ng production order and a copy of the warrant for the disclosure of computer data. The law enforcement authority are also required to file initial return kapag search, seizure, and examination, final return, and for other warrant, they are required to file return within 48 hours. So, what are the sanctions once these obligations ay hindi nagawa nung layas and the service providers yung mga obligation na to? So, for failure to file a return, for failure to turn over custody of items disclosed, and non-compliance with layas order to disclose, ang sanction would be contempt under Rule 71 of the Rules of Court. On the other hand, non-compliance with the orders of the LEAs, you can be charged. The service providers or the person with knowledge of the functioning of the computer system may be charged for obstruction of justice, and it would be filed in the Cybercrime Court, which is jurisdiction of the place where the non-compliance was committed. These sanctions are provided under Section 2.6 and Section 2.7 of the Rule of on Cybercrime Warrants. Okay, except for the warrant for the disclosure of computer data, lahat ng items na na-seize nyo, you need to turn over it to the court upon filing of the return, diba? So once deposited, all the data turned over to the custody of the court shall not be opened, played, or revealed, or used as evidence except upon motion granted by the court. So upon deposit to the court nung mga computer data na nakuha nyo based on this cybercrime warrants, gusto nyong gamitin tong mga data na to, you should file a motion first with the court stating the relevance of using the computer data or relevance of accessing the computer data. Provide the names of the persons allowed to have access to this computer data, and give proof of service to the person whose computer data is subject of the motion. Okay, so hindi kayo basta once na na-deposit nyo sa court, hindi kayo basta-basta magkakaroon ng access at hindi nyo basta-basta agad magagamit yung computer data. You still need to file a motion with the court to access and use the computer data that were deposited with the court, except yung computer data na nakuha nyo through the warrant for the disclosure of computer data, because that warrant also gives you the authority to retain a copy for the purpose of investigation or preliminary for the purpose of case investigation or preliminary investigation. Okay, as I said, there are cybercrime courts who can issue warrants with extraterritorial service. Diba? So, ito yung mga warrants na gusto nating iserve sa outside of the Philippines. So, kapag ang subject natin service providers outside of the Philippines or persons who have custody of computer data, the service of these warrants shall be coursed through the Department of Justice Office of Cybercrime. Like for example, as I said earlier, Facebook, a foreign entity, if meron tayong isuserve na warrant sa kanya, ang magsuserve after getting the warrant, the service must be coursed through the DOJ Office of Cybercrime as provided under the cybercrime law and the rule on cybercrime warrants. Okay, so that's the discussion on the relevant provisions of the rule on cybercrime warrant. I suggest that you read, medyo mahaba-haba yung rule on cybercrime warrants. What we discuss are just the relevant provisions na mahalaga na malaman nyo as part of the law enforcement authorities, and the relevant then in the upcoming sessions, especially on your the main sessions on digital forensic analysis and investigation.